Okay. So hello everyone, and welcome to my Drugs and Deportability workshop. And you should have gotten the handout that I prepared along with it, which basically has my agenda and explains what we're going to do. It also has room for notes, so feel free to take notes, and we'll ask questions at the end of the presentation. Okay? So maybe before I begin, my name is Otis Landerholm. I'm an immigration lawyer. I fight for the rights of immigrants who are facing deportation, and welcome to my office. It's wonderful to have you all, and so yeah, we'll jump right in and get started. The plan for today is first to do sort of a introduction to immigration law as a kind of broad topic. I know that sometimes we use a lot of terms, or we use a lot of jargon that is very familiar to immigration lawyers but is not necessarily super familiar to criminal defense attorneys, and so I just want to sort of get all of the big broad immigration law issues out in the open. Then I want to do an intro to what we call crimmigration, sort of the intersection between criminal law and immigration law. Then we'll go into depth on the penalties for drug offenses and what the consequences on someone's immigration status would be for having a drug conviction. Fourth, we'll talk about we'll talk about criminal defense strategies. So what's the best way to prevent a conviction or to prevent nasty immigration consequences for an immigrant who's been charged with a drug crime. And then 5, we'll talk about an overview of their relief after they're done with the criminal court process and once they're transferred to immigration court. So that's the plan. Are we good on that? Perfect. So my immigration law intro. Basically, the question is always, what do immigration lawyers do? And to make it very, very simple, we do two things. One, we help immigrants come into the United States from overseas, and 2, we help immigrants stay in the United States once they're here. Okay? How do we do these things? We do it through various processes. The most common are first visas, second green cards, third asylum, fourth U.S. citizenship, and fifth deportation defense or removal defense. There are some other things that we do as well. I'll talk briefly about each of these as we go forward. Visas, you'll recall, or you probably know what they are. Visas are basically permission that goes inside of your passport that allows you to get on a plane and cross through customs and to be admitted to the United States, usually for a temporary period of time, and it's usually for a specific purpose. These are the big list of the majority of visas. So in the upper left-hand corner, you have A visas for ambassadors and diplomats, and in the bottom right-hand corner, you have VAWA, U visas. It sort of goes all the way down the alphabet, from your visitor visa to your student visa, and all the way through. The point is that they're specific to time, and they're specific to the purpose for your visit. Versus the second thing that we do, which are green cards. Green cards are for any lawful purpose, and they are permanent, and that is why they are so much more valuable than visas are. The third thing that we do is asylum. So for people that are afraid for their lives, they are running from danger or violence in their home country, and they're asking for protection from the U.S. government, and so they ask for asylum here. The fourth thing we do is U.S. citizenship, and basically anybody that's had a green card, usually for a period of 5 years. There are exceptions to that, but usually for 5 years, you can apply to become a U.S. citizen. And the fifth thing, of course, is defend people from deportation. Okay? So that's sort of your immigration law overview. That's basically what immigration law is all about. Are there any questions as far as that goes? We're all on the same page? Perfect. All right, so regarding crimmigration now, so the intersection, really, what is crimmigration? This is a term of art that that really immigration lawyers use a lot. So it's the intersection between immigration law and criminal law. This graph is a graph I like to show a lot. It shows the number of deportations out of the United States per year in U.S. history. It shows that right now, really, Immigration law changed in 1996 for the worse and caused a whole ton of people to get deported. And right here on the graph you can see when 9/11 happened, after 9/11 and then the passing of the Patriot Act. We had an increase in government programs, and we had an increase in, I think, bad law that has caused a lot of people to be deported on a yearly basis. And we are feeling the aftermath of some of these laws that have passed and some of these programs that have been implemented right now. And this is kind of what we are here to help fight against. A huge bulk of these people that are getting deported are being deported because of criminal charges, or for quasi-criminal reasons. So there are three kinds of crimes for immigration purposes. All right, there are crimes that make you inadmissible, deportable, or what I say, screwed for life. Okay, so we'll talk about each of these. All right, crimes can make you inadmissible, and the way to think about this is, and I could tell you a story, one of my clients about this, which I think I will a little bit later. Imagine that you commit a crime in your home country, and then you go and you apply for a visa, and you've never even been in the U.S. before, right? So imagine that you, when you were 19 years old, you committed a robbery, like you did something bad in your home country, you were charged, you were convicted. And now, 50 years later, you're an old man, and you have long forgotten about the bad thing that you did in your youth, and now you'd like to spend your retirement traveling around the world, and you'd like to visit the U.S. You will not be allowed to. When you apply for a visa, you will be deemed inadmissible, and you will basically be ineligible for any visa, regardless of the type of visa, for the rest of your life, unless you're eligible for very, very narrow categories of waivers. But regardless, your crime will have made you inadmissible. Now, some crimes make people inadmissible, and some crimes don't. And if people are convicted of something and they want into the U.S., often they will call an immigration lawyer to determine, okay, let's look at that criminal record and let's determine whether or not you actually are inadmissible or not. And it will depend on the criminal record and the state of the law, and how U.S. immigration law applies the conviction that happened in your home country. So it's a complex analysis, but it's something that an immigration lawyer can help with. Okay, the second type of crimes are crimes that make you, quote-unquote, deportable. So imagine that you already got that visa and you're already here as a student studying at UC Santa Cruz, and you are found with a certain amount of marijuana in your dormitory, right? Or imagine that you are convicted of any type of crime, right? So some of those crimes may make you deportable. What does that mean? That means that the U.S. government can actually take away your visa and can put you into deportation proceedings and can deport you out of the country, okay? So certain crimes make you ineligible for the visa to begin with. Other crimes, theoretically slightly stronger crimes, although many of them overlap, are enough to allow the government to take away your visa or your green card or other types of immigration status and actually put you into deportation proceedings. All right, here's the point. There is relief in certain instances for people who are quote-unquote inadmissible or for people who are quote-unquote deportable. All right, these people potentially qualify for waivers, for cancellation of removal, for asylum, for U visas, for special immigrant juvenile status, for DACA. I don't expect you to know any of these things, but the key is there are arguments that immigration lawyers can make for people that have criminal convictions that fall into either of the first two categories if the circumstances are right. But this category, there's no such argument, and it would actually screw you over for the rest of your life regardless. This category is what we call aggravated felonies, which sounds really bad, aggravated felonies. And originally, it was really bad. Originally, it was listed, it was just defined as murder, federal drug trafficking, and firearms trafficking. So those are all pretty bad things to do. But now, and as the laws have progressed over the years, the definition of what constitutes an aggravated felony has now expanded very, very broadly. And it includes like a simple battery with a 1-year sentence imposed is a crime of violence and an aggravated felony. You know, anyway, there are many, many convictions that someone could be charged with and convicted of that now will really, really have nasty consequences on their immigration future. Okay, I explained sort of at the bottom of this slide what an aggravated felony would do to you. Basically, it means that the government has to detain you, so there's mandatory detention. You're ineligible for any bond throughout the process. You are going to be detained as you go forward. You're going to be ineligible for asylum. So I don't care how dangerous your home country is, you will not qualify for asylum. You could potentially qualify under the Convention Against Torture, which is cat relief. You'll be ineligible for waivers, so I don't care how much hardship your family will be suffering if you are deported. You aren't going to qualify for them, with the narrow exceptions of U, T, and S visas. But even for U, T, and S visas, it is very difficult to convince the government to waive an aggravated felony. And you're ineligible for cancellation of removal. All right. Also, if you're undocumented, you're even ineligible for a hearing in immigration court. So your due process rights in court are limited. If you have one of these convictions. So the big takeaway, if you get nothing else from this presentation, it is when charged with an aggravated felony, do your utmost to not plead guilty to it. Try to have your clients plead guilty to something else if they are at all interested in staying in the U.S. All right. So the big point is to know how a crime will affect your client's immigration future, and to plan accordingly is to really fight for your clients, right? And of course, it's also to help each of you not commit ineffective assistance of counsel. So you don't want to commit ineffective assistance of counsel, and what Padilla versus Kentucky Supreme Court case said is that if criminal defense attorneys are not giving advice about the pleas that people are entering into, that does not, if they're not informed of what the immigration consequences of that plea will be, it's ineffective assistance of counsel and they can throw out the judgment, right? So it's malpractice, okay? So fight for your clients and know how their plea will affect their immigration outcome. All right, so now the point of my topic today is not to talk about crimes generally, but really to focus in on drugs, because I think there's a lot of overlap, and I think people, I mean, hey, we're in Oakland. We're in Oakland, California. There's a lot of drugs, right? There's a lot of people that are convicted of drugs, and there's a lot of people that get put into deportation proceedings because of arrests related to drugs, and so that's the point. So, all right, so what are the penalties, the immigration penalties of being convicted of a drug offense? So we just sort of went over this generally, but, you know, but just to reiterate, drug offenses make you inadmissible, and really what immigration law says is that a conviction of a crime, quote unquote, relating to a controlled substance causes inadmissibility. Okay. Also, there are ways that you would become inadmissible without a conviction. So there are conduct-related grounds of inadmissibility. So if you're a current drug addict or drug abuser, you will be found inadmissible, right? If the Department of Homeland Security has quote-unquote reason to believe that you have ever trafficked in drugs, you will be inadmissible forever. And then third is if you formally admit all of the elements of a controlled substance conviction, then you will be found inadmissible. So there's an interesting story of one of our clients She was in Canada, and she was crossing into the U.S., and the Customs and Border Patrol stopped her and asked her whether or not she'd ever done anything bad, and kind of grilled her on it. And she admitted to having used cocaine once at a rock concert in Vancouver, Canada, before coming in, right? And for some weird reason, the Customs and Border Patrol agent said, oh, okay, here's your visa to enter the U.S. as a tourist, right? So she was admitted. She was in our office. She was here, and she wanted to apply for a green card. She married a U.S. citizen and wanted to apply for a green card. I look at these facts, and I say, I am sorry. You will waste your money hiring my office to help you apply for a green card, even though you are now married to a U.S. citizen. There is no way that you're ever going to qualify for a green card because you have admitted the elements of a controlled substance. You have admitted the essential elements of a controlled substance conviction, even though you weren't convicted. You're never going to get a green card in the U.S. Sorry, I can't help you, right? So she's not in jail. She's never been to jail in her life, but she has immigration consequences, and it's an interesting, anyway, so things to think about. Second issue about drugs. All right, so drugs also cause deportability, right? A conviction of an offense, quote unquote, relating to controlled substances causes deportability, and also anyone who has been a drug addict or abuser at any time since they were admitted, right? So they're here now, and now they entered as a tourist or maybe as a student, and now they become an addict while they're here. Boom, even no conviction, they're deportable. And then, of course, aggravated felonies. Aggravated felonies can be state convictions for drugs can be aggravated felonies in two ways, all right? First is if it's trafficking, which means in California, crime, it's either sales or possession for sale, okay? If you're convicted of either of those, it's an aggravated felony. Or two, if the conviction is analogous to any of the federal drug offenses that are referred to in the aggravated felony definition, which is basically, what do I call it? Flunitrazepam. It's the date rape drug. A conviction for simple possession of a date rape drug is an aggravated felony, regardless of as long as it's more than 5 grams. No. Any amount of flunitrazepam, even simple possession of more than 5 grams of cocaine base, are going to be an aggravated felony. Okay. What is the takeaway here? Avoid trafficking and avoid those drugs. Generally speaking, being under the influence, being convicted for use of a drug, being convicted of possession of paraphernalia, being convicted of being in a place where drugs were being used, are generally not aggravated felonies. Those are safer pleas to have your client plead guilty to than trafficking, than sales. Okay? Are we clear so far? All right. So the fourth potential penalty, immigration penalty for a drug conviction, is a bar to asylum and to withholding, and that's basically limited to what we just looked at as the aggravated felonies. So drug trafficking. Drug trafficking constitutes a particularly serious crime, which is a bar to asylum and to withholding of removal. There is a narrow exception for pleas that were entered into before March 5th of 2002. I don't want to worry about that. The point is, if you know somebody that's looking to apply for protection, asylum, here in the U.S., be very careful if they're in a criminal process and what you're pleading to. Okay. So with that, right, we have crimes that make you inadmissible, crimes that make you deportable, and crimes that are aggravated felonies that screw you over long term. What are the strategies? Okay, and so the next piece of this, I want to talk about really what strategies a criminal defense attorney can use to help your clients out. Strategy number one is to get something that's not a quote-unquote conviction. And this is where immigration law gets a little bit tricky. immigration law is federal law, and most crimes are state-based. So we're talking about California crimes. Convictions under federal law, under federal immigration law, require two things. They require first a finding or an admission of guilt, and second, they require some form of penalty or restraint against a person, right? So there are a couple of things that are sort of okay for immigration purposes most of the time. The first of which is juvenile delinquency dispositions. The law has said that they are not quote-unquote convictions for immigration. Why that is, I don't know if it's because there's not a formal finding of admission or guilt. I think that juvenile proceedings are civil proceedings in nature. They're not deemed criminal proceedings. And so it's not a quote-unquote criminal conviction. The second option is a pre-plea diversion program. You may have heard of, like, go into perhaps a drug program instead of, in lieu of pleaing, right? In certain instances, this can avoid finding of guilt, right? The third thing I talk about is deferred entry of judgment. A deferred entry of judgment with a quote-unquote unconditionally suspended fine. This is a little bit complex. The only reason I bring it up is because there is a Ninth Circuit case that discusses this issue. What they're really talking about is the unconditionally suspended fine issue. If it is a fine only, and there is no putting somebody behind bars, and there's no otherwise like restitution and damages or money that needs to be paid as part of this, or fine that needs to be paid as part of the conviction, then there's no punishment. And if there's no punishment, then there's no conviction for immigration law. Does that make sense? All right. And then there's a debate about whether or not under California law an infraction, if it's not really a misdemeanor or felony, if it's listed as an infraction, it might not qualify as a conviction for immigration purposes. Okay. Second strategy, I think there are 8 of these, just to put everybody on the radar. The second strategy is to plead to a quote-unquote non-drug offense whenever it's possible. So the example that I have here is Penal Code Section 32, which is basically you would plead guilty to being an accessory after the fact. Even if it's an accessory after the fact to, like, you were an accessory, you were helpful in some way in the, I don't know, in the transportation of drug paraphernalia, say. Transportation you got to be careful with because it could be trafficking. But generally speaking, being an accessory after the fact to something is a safe plea, because being an accessory after the fact is not under the health and safety code. It's under the penal code. And remember, under California law, drug offenses are listed. They're categorized under the health and safety code of criminal law. Okay? All right. So, however, you got to be careful with even an accessory after the fact plea, because if you are sentenced for more than a year based on it, and depending on what the underlying plea is, it could still be an aggravated felony. Okay, so you got to be careful of how long you're being sentenced to, but generally speaking, this wouldn't be a drug offense. All right, third strategy. In certain instances, it works to keep the record of conviction vague, to not have the specific controlled substance mentioned. So for example, imagine our student at UC Santa Cruz is arrested for, let's say it's possession of cocaine, right? Simple possession. Imagine that what you would do here for this person is you would, and I sort of explain this down here, possession of cocaine. What you would do for this person is, on the record, you would black out, you would amend the charges in criminal court, you would black out the fact that it says cocaine, and you would just say possession of a quote-unquote controlled substance. Vague, does not specify which controlled substance. It's just, I'm only pleading guilty to possession of a controlled substance. I'm not pleading guilty to possession of the specific controlled substance, cocaine, right? So this only works as a defense in immigration court for people who are green card holders. And the reason it works for green card holders is because the burden is on the government to prove that green card holders are deportable, right? And the government will only be able to prove that they're deportable if it says that the controlled substance at issue is a controlled substance under federal law, not just a quote-unquote controlled substance under the state laws of California. It's a strategy. It's a very, very narrow strategy, but it is a workable strategy if you're working with someone with a green card who only has, who is not otherwise deportable for any other reason. Okay? The flip side of that coin is it is also okay to plea to a specific controlled substance that is one of the substances that is a controlled substance under the state of California, but not one of the controlled substances under federal law. You follow me there? There are like a very small number of these substances, right? They are androxysosable, I can't even say them, bolandiol, boldenonine. I mean, they're just like these very, very strange, very chemical substances that are drugs that are outlawed in the state of California, but not federally. If you were to plead guilty to, you know, possession or use or being under the influence of one of these, you would not be committing a quote-unquote controlled substance conviction for the purposes of immigration law, because immigration law depends on federal law, and it's only looking at controlled substances that are federally recognized. The danger of this is, first of all, it's going to be difficult to convince the court and the prosecutor that you're trying to negotiate a plea with to basically agree to a legal fiction if it was not actually one of these substances. So there's some nuance there. You've got to have a good relationship with your judge and your prosecutor. The second issue is a safe plea today could potentially become dangerous later once the federal controlled substance lists get updated to include more and more substances. Does that make sense? Yeah. So you're treading on thin ice by doing it, but I would still take that case in immigration court and we would still put our arguments forward. It's better to be on thin ice than on nothing. Okay? All right. The fifth strategy is 30 grams or less of marijuana. So, okay. Being convicted of simple possession of 30 grams or less of marijuana will make you inadmissible, but it will not make you deportable. Okay? So it's safe for green card holders to plead guilty to this. It's safe for refugees and asylees to plead guilty to this. It would cause problems, though, for undocumented folks or for people that are otherwise trying to get immigration status. However, waivers are available. This might be my 1 o'clock appointment. Okay. Okay. The other thing about this is that it is up to the, it's up to us, it's up to the immigrant, right, to prove, 1, that it was marijuana, and 2, that it was less than 30 grams. Okay. The sixth thing I want to say is a note regarding paraphernalia. Okay, so a conviction for possession of drug paraphernalia is both inadmissible and deportable, and it doesn't matter whether or not the specific substance is identified. So numbers 4 and 5 that I mentioned work for possession and work for use, but they do not work for possession of paraphernalia, because it doesn't matter what the controlled substance was that the paraphernalia was for. The possession of the paraphernalia itself will make you deportable. Okay, and sales of drug paraphernalia can be an aggravated felony, so be careful about anything related to sales. Okay, the seventh thing I want to mention is under a case called Lujan Armendariz. We always call it Lujan. Basically, the law has since changed, but if the plea was entered into before the 15th of July of 2011, there are ways to get things expunged. There are ways to change the record after the fact, and those changes could help somebody's immigration case. It would basically undo a controlled substance conviction. So again, you have to have pled, oh sorry, this is limited to possession. I should have said that from the beginning, so it doesn't work for under the influence. Limited to possession charges, had to be a plea that was entered into before July 15th of 2011, and it has to basically have no violation of anything else going forward, no probation, no prior plea diversion, and no other crimes. And then it can be expunged and taken away that way. All right. And then drug aggravated felonies, basically we're talking about drug trafficking, sales, possession, things like that. Avoid them whenever possible. Simple possession is not an aggravated felony, so that's a safer plea. There are also aggravated felonies to kind of watch out for. For example, forging prescriptions could be an aggravated felony. Cultivation of marijuana is a big one, because now with California state law, there are people that get licenses to grow. Don't do it if you're an immigrant. Okay, it will screw you over forever. Distribution of controlled substances for free. This is not a sale, right? But it's still potentially an aggravated felony. So maintaining a place where drugs are sold. Each of these can be aggravated felonies. All right. So all of that is the criminal court stuff. So do the best you can to have a plea that could potentially help or not screw over your client as best as possible, and be in touch with an immigration lawyer as you make those pleas to really see what the consequences will be and whether or not we can work around it. Okay. The last part that I want to talk about is after your client or our client has been transferred out of the criminal defense process, whether they were imprisoned or not, they will be transferred to immigration court. Usually they would be given a nice hold, and usually immigration would come and pick them up. So just really briefly, I'm not going to go too much into this. Once you're in immigration court, that's when my office works our magic, and that's when we go to war, right? And so how do we do that? There are basically, I think I have 8 things listed here. The first thing that we can do is what's called a contested hearing. A contested hearing is basically saying in front of the judge that no, I am not deportable. No, the conviction that I pled guilty to does not make me deportable, judge, and here's why, right? No, here's my green card, and it's still a valid green card, and I haven't done anything wrong to put me into deportation proceedings, so I contest the fact that I'm deportable to begin with. So anyway, that's option one. The second option is what we call cancellation of removal. There are actually many different laws under cancellation of removal, but the main two, one is for green card holders and one is for people who are undocumented. Basically, if you've got a criminal conviction, you're not going to be eligible for it if you're undocumented. The third thing is asylum withholding and relief under the Convention Against Torture. Again, we've got to study very carefully what the convictions were to make sure that you're eligible. I'm going to jump to 5 because that's what the number says here. The fifth thing is for family-based green cards. So in certain instances, just because you have a conviction, you could still be eligible for a family-based green card. Generally not if it's a conviction for controlled substances. Okay? Otherwise, you might be able to qualify for a family-based green card with a waiver, for example, if you're married to a U.S. citizen. The sixth thing that we do are U visas. U visas are visas for victims of crimes. U visas are powerful tools, and they can help people waive even drug offenses, even aggravated felonies, depending on the facts. Okay? The seventh thing on my list are motions to suppress. I want to mention them to you all because if you see that the police has violated your client's rights in arresting them, even if it's for drugs, whatever, and don't ignore it. And I know motions to suppress are huge tools in the toolbox of any criminal defense attorney, so I know that it's not being ignored. But if it were ignored and a plea were accepted, then we could waive it. And you don't want to waive it because we want to be able to make that argument once we're in immigration court. But where it often comes up, or where it's more likely to come up, I should say, is if you had a motion to suppress that you won on the criminal defense side, and now our client gets picked up by ICE for the same thing, we could renew that motion to suppress once we're in immigration court, and we could have success with that. Anyway, we would hope to have success with that. The last thing, I mean, there are lots of other ways that we can apply for immigration relief. There's temporary protected status, there's special immigrant juvenile status, and there are many other ways that we can help people once they're in the immigration court side. I guess the point of all of this, before we get to our Q&A, is criminal defense attorneys and immigration attorneys can work together as we go through the process and as our clients go through the processes, so that we can best help them, one, stay in the U.S., two, be able to return to the U.S. if they want that, or three, really avoid the horrible disruption to anybody's family and life that is deportation. Okay, so thank you very much for being here. I'm going to turn the video off and then we can ask questions. Okay, thanks.